the afternoon session of the Court of Appeals. I'm Judge Arnold Golden, and joining me on the panel today are Judge Carmer McGee and Judge Kenny Armstrong. And we're looking forward to hearing your case today. I just want to point out that each side will have 15 minutes. The appellate can reserve up to 5 minutes for rebuttal. Mr. Hivner, will you please call the case?
Kenneth Washington versus City of Memphis.
May it please the court, I'll proceed.
Please state your name.
I am Herman Morris, attorney, Memphis, Tennessee, 119 South Main Street, Suite 500.
And you're reserving time for rebuttal?
I'm reserving 5 minutes for rebuttal and would ask to be notified when I'm at my 10-minute mark so I don't run over.
All right, you should have a clock on there. Do you see it?
Not yet, but I'm sure it'll pop up.
Okay, all right. Go ahead, please.
May it please the court. I'm Herman Morris, and I'm representing the appellant, Kenneth Washington. Mr. Washington is appealing a decision that began with the Civil Service Commission in Memphis, Tennessee. It's an appeal of his termination as a code enforcement department inspector for violating a union MOU and the city policy. The union MOU said that it was inappropriate to solicit work while on the job from others. And the policy said that it was inappropriate to solicit a bribe, a fee, or other items while on the job. And those are the primary policies. Those are the ones that arguably were serious enough to warrant a termination. And in fact, the MOU explicitly says that it is a termination offense. There's another policy that relates to inappropriate conduct. It's the catch-all policy at the city that we use for things like employees who are off work and have DUIs or have domestic events that become noteworthy and newsworthy. Our basic argument is that the MOU, which he was charged with, was unenforceable and was removed from the case by the trial judge. The bribery charge, which he was charged with, was stipulated out of the case by the parties, and that the balance of the case rested on what is basically uncorroborated hearsay. The gist of the case is that Mr. Washington, as a code enforcement inspector, was charged with inspecting a large apartment complex in Memphis, in South Memphis, some 600 odd units, 70% of which were vacant and dilapidated and were being vandalized, quite frankly, by people in the community. He had been there a few times and had cited them on at least one prior occasion, and he reported back to his superiors. At or about the time that he was doing his work, he had a chance to speak with the apartment manager, Mrs. Lloyd, or Ms. Lloyd. And she basically was unhappy with the conversation. She knew he had been on the property and he had cited them before. And as a result of that conversation with her, she basically did a letter to his supervision, essentially saying, A, that he had spoken with her employees and intimidated them, B, that he had acted inappropriately, and that she was upset about it. The supervision followed up on the case and did a summary of his conversation with Ms. Lloyd, which ultimately resulted in the termination of Mr. Washington for the charges of soliciting business and violating the policies. Well, the problem with all of that is that Ms. Lloyd based her, Mr. Washington is soliciting business and is intimidating my employees' opinion on a conversation that she had had with her staff. She didn't have that conversation with Mr. Washington. She had a conversation, I'll touch on that later. But when she reported it to the city code enforcement supervision, she said that he was intimidating employees and that he was soliciting business. That then started the hearsay ball rolling. That was clearly hearsay, as she was not present when that conversation allegedly took place between Washington and her employees. And that hearsay basically permeates the entire case. And that essentially is the city's case. There's one other conversation that is worthy of mention, and that is a conversation between Mr. Washington and Ms. Lloyd. And the gist of that conversation, and the chancellor at the trial acknowledged as well, she was asked, did Mr. Washington ever ask you to let him do the work to repair your 620 odd unit apartment complex? And she said no. Mr. Washington was asked, did you ever ask to be allowed to do the work to repair the apartment complex? And he said no. So the only testimony regarding that conversation from the two people who were present and involved and engaged in it is that he said, she said, he said he never asked, and he said he never asked. The gist of it, as we see it and would argue to the court, is that this started as a charge on an unenforceable memorandum with the union that said if you solicit business, it's a termination offense. Well, that's what that MOU said, but that's unenforceable and it's out of the case. It also has a personnel policy that makes bribery or soliciting a bribe, a fee, a favor, et cetera, a significant violation. It doesn't say that it's a termination violation in the policy. It simply says that it's a significant, it simply, and by its weight, bribery is a serious issue. That's out of the case. All that remains in the case, quite frankly, is the allegations that are based on uncorroborated hearsay, which at this point is not available as the basis for sustaining a termination. Now, when it was heard before the Civil Service Commission, and I am not seeing the clock, so on my screen, but when it was heard—
2.5 minutes, 2.5 minutes, Mr. Morris.
When it was heard before the Civil Service Commission, they considered the MOU, they considered the bribery policy. And they said, well, if he did this, then he's worthy of being terminated. When it was heard before the chancellor, those items had been removed. But when he rendered his decision, he based his decision on the decision of the Civil Service Commission, which relied on those ineligible items as part of the record as a whole. Our argument is that once you remove the MOU, once you remove the bribery issue, once you remove the uncorroborated hearsay, the record as a whole is not sufficient to satisfy the standard of substantial and material evidence to support what was done. And that since all of this is a question of law, and I would say even the testimony of the two witnesses on the critical issue of did he ask, since all of this is a question of law, I think it's appropriate for this court to make a decision and resolve the case completely.
Any questions? Or do you still have your rebuttal time, Mr. Morris? Thank you.
Thank you.
Okay, we'll hear from the city. You're mute. You're mute, Mr. Hawkins. Still moot. You're gonna have to turn that on your screen, Mr. Hawkins.
Check your audio.
You should have an audio cut on there.
No.
Check the volume.
Oh, the volume? Okay.
Mr. Hawkins, on the bottom left-hand side of your screen, you should see a mute button, and then there's a little caret beside that mute button. Open that up and click audio settings, like a little arrow. Then in audio settings, you'll have to choose which microphone you want to use again. Should be your internal microphone. And you can hit test mic, and that should click it back on.
Is this working now?
Yes. Now, yeah.
I apologize to the court and to the clerk. It worked when Mr. Hivner and I tried it earlier. I apologize.
It's not a problem. Go ahead.
Thank you, Judge Golden, and to the court. My name is Dennis Hawkins, and I represent the city of Memphis as the appellee in this case. If it please the court, the termination of the appellant was found to be based upon just cause, which is required by the ordinance of the city of Memphis. The commissioner found that the city had just cause to terminate the appellant upon review by Chancellor Kyle out of Part 2 here in Shelby County. He likewise found that the city had just cause to terminate the appellant.
Mr. Hawkins, did he apply the correct standard in making that determination?
Well, Judge Armstrong, there's no doubt that courts speak through their orders, and that Chancellor Kyle did say that the standard is preponderance of the evidence in his order. I can't say why that is in the order. The city has been consistent after it left the Civil Service Commission that the standard of review is TCA 4-5-322. It said that in oral argument before the chancellor, and its standard of review in the brief submitted to the chancellor should be almost identical as the one submitted to the Court of Appeals. There's no
in his written ruling, he didn't indicate that he found that the evidence was substantial and material, which is required by the statute. Is that right?
Actually, Judge Armstrong, it's the city's position. The statute reads under 4-5-322H. There are 5 enumerated articles there, which would have to be shown that the city did not reach those. In other words, was the decision arbitrary and capricious, or was it not based upon substantial and material evidence? What the chancellor found after a thorough review of the record, and he cited it numerous times in his order, he says, after reviewing the record as a whole, and he does cite 4-5-322G. So he's operating under the right statute in the order at one point, but I cannot read his mind. I would not try to as to why that language about what is essentially a burden of proof is in there. But what I can say, Judge Armstrong, is that the standard of review after it leaves the Civil Service Commission is the same in Chancery Court as it is before this Court of Appeals, as it is before the Supreme Court. So,
but do we make the initial decision though about whether or not there's substantial and material evidence in the record to support the termination, or is it the trial court's obligation to make that finding initially? And then what we do is review it to determine whether there's substantial and material evidence in the record to support that determination. And that's how it's done.
Well, Judge Armstrong, I would say in this particular type of case where it's an administrative hearing, the Supreme Court in Davis v. Shelby County against the Shelby County Sheriff's Department made clear that the standard of review remains the same at the Court of Appeals as it did at the Chancery level. So when Chancellor Kyle made his determination that the termination of the appellant was based on just cause, Mr. Morris has appealed to you all by right, and the analysis now is to be conducted under 4-5-322. So with a fresh set of eyes, you all are to review the record and make your determination to either uphold the Civil Service Commissioner's termination or to reverse that. Certainly, I can't speak to how you all should address Chancellor Kyle's order. That's not for me to say, but I will say the analysis has been made clear, and it's 4-5-322. Additionally, the bulk of appellant's argument is related to credibility determinations and the weight of the evidence. And what I would remind this court of is the Western District Court of Appeals, you all have spoken on that issue. In Mitchell versus Madison County Sheriff's Department, the Court on Appeal is required to give great deference to the commission's determination of credibility of the witnesses. The original trier of fact, Commissioner Hardaway in this case, heard the testimony live, observed the demeanor of the witnesses, and then reviewed the transcript before making her very detailed determination. And it's hardly a unique circumstance in this case that one person testifying said a conversation went one way and another person testifying said it went another way. As you all are aware, as former trial judges, the credibility determinations come up almost in every case. And the commissioner made such a determination in this case. And I will address one thing Mr. Morris said about the testimony that was given about Ms. Lloyd, the apartment manager, saying he didn't say let him do the work. But as we pointed out in our brief, and as I'll mention here, on the technical record, volume 3, page 65, lines 13 through 20 of her testimony, she says, let me back up. I don't want to make this harder than it is. The conversation with Mr. Washington, his conversation with me was, you have a lot of issues on this property. I can help you get those done. I'm a contractor. I will be able to do it cheaper because I know the property and I have the manpower. Those were his exact words. That's a block quote from her testimony given live. So the notion that there's uncorroborated hearsay based on a letter in this case is simply not the facts. There was Ms. Lloyd live to give testimony, and I just read it to this court and it's cited in our brief. The other notion here on that particular issue is Exhibit 4, the letter Ms. Lloyd wrote. And I want to be clear, that was not the city's exhibit. That was Mr. Morris's exhibit. He introduced it. And it seems difficult to process now that he objects to it when it was his exhibit admitted into evidence. So to finish up on hearsay, as you all are aware, the Civil Service Commission in Memphis was found under Marino versus the City of Memphis Retirement Board to operate under the Uniform Administrative Procedures Act. And if we go look at that act, 4-5-313 states that the agency shall admit and give probative effect to evidence admissible in a court when necessary to ascertain facts not reasonably susceptible to proof under the rules. Evidence not admissible thereunder may be admitted if it is a type commonly relied upon prudent men, and the legislature needs to add women there, in the conduct of their affairs. So it's clear that a fact finder like Commissioner Hardaway can entertain letters and evidence of the sort, and that a strict hearsay rule is not applied at the civil service level. The appellant, the appellant states in the brief and then did here today that 38-026, the city personnel policy related to solicitation, was, quote, stipulated out of the case. And the city's position is simply that that's not what happened. The city never charged the appellant with soliciting a bribe, but they did deem that he had solicited to do private contractor business on a property on which he was carrying out the code enforcement regulations of the city of Memphis. And that while acting in his employ as a code enforcement official, he could not then seek private contractor business on that property. And the appellant is virtually silent on the other City of Memphis personnel provision that Director Kenneth discussed, which is 3802 subparagraph 17, which states that such conduct as in this case would be incompatible legally, technically, morally with his duties as a city code inspecting official. And that stands to reason because it would not pass muster for the individual inspecting, citing, and then ultimately determining whether or not that property passes to be the one to go do the maintenance and repair work to get it in line with code. That's what Director Kenneth said was so egregious and rose to the level of breaching the public trust. So the fact that an appellant is silent on that provision really is telling, and the city would state that it was just to go under 3802 paragraph 6 and paragraph 17 to terminate Mr. Washington. Finally, again, Judge Armstrong, to address your concerns, it's the city's position that regardless of the language used by Chancellor Kyle, he did cite 4-5322. He cited subsection G, which states he is bound by the record before him. He can't go outside of it unless there was an issue unresolved. It also says that the matter is to be heard without intervention of a jury. So that is part of the standard of review. And he cites repeatedly, as I stated earlier, throughout his order, that he did review the record as a whole. And what he found was that just cause existed for the city to terminate the appellant. That's leaving the decision of the commissioner intact. It would make sense that he didn't list any of the items under subsection H of 4-5-322 because he didn't find that any existed in this case. So I hope that answers your question, at least from the city's position standpoint. With that, that concludes everything I had prepared. I'm happy to entertain other questions or rest at this point.
I do have one question. Are you saying in response to Judge Armstrong's concerns that we can look at it the same way that Chancellor Kyle had the opportunity to look at it and reach our own conclusion? Are you saying that?
Judge Golden, that is what I'm saying, because I think the Supreme Court made it clear in Davis v. Shelby County. In fact, I think that came out of your part of Chancery, if I recall correctly. And the reason the Supreme Court took that case on was because the Court of Appeals applied the wrong standard. And they wanted to make sure to clarify, and their exact language was that the standard of review for these types of cases is the same at Chancery level, at Court of Appeals level, and at the Supreme Court level. So yes, I do believe, as you stated, Judge Golden, that is what this court could do.
All right, thank you.
Sorry, in the case you cited, did the trial court apply that substantial and material standard in making a determination about the discipline in that case?
Judge Armstrong, Chancellor Golden in that case, at the time, Chancellor Golden, did apply 4-5-322. I think, if I could, just to clarify, the substantial and material evidence provision you're citing is actually under 4-5-322H 5A. and it says that it can be reversed, and this is only for these reasons, right? And so 5A says, if it's unsupported, if the commissioner's decision is unsupported by evidence that is both substantial and material in light of the record. We would submit that there was substantial evidence in this case to support the termination, and the chancellor's omission of that particular provision of statute is not fatal in the conclusion he reached, because he found there was substantial and material evidence to support the city's position. Thank you.
Thank you. Mr. Morris, you have 5 minutes for rebuttal.
Okay, well, first let me apologize to the court for my lack of technological savvy and getting on to the hearing. I appreciate the consent of the clerk in assisting that to happen, and I too hope that that's not something that's held against my client, and likewise I can appreciate the issues that Mr. Hawkins had. I was there also. Credibility of witnesses, getting to the argument, credibility of witnesses. I don't think there's a witness credibility issue, because the witnesses are saying the same thing. Did he ask to be allowed to do the work? Was the question that was posed to Ms. Lloyd after she made her little soliloquy about, let me get this down to the brass tacks. Did he ask Ms. Lloyd to be allowed to do the work? She said no. He didn't ask. Mr. Washington was asked the same question. Did you ask to be allowed to do the work? He said no. I think the witnesses are in agreement. There's not a credibility issue. That fact is established between those two witnesses. The uncorroborated hearsay that's found in Exhibit 1 and Exhibit 4 is really a deal breaker for the city.
Mr. Morris, wasn't Exhibit 4 your exhibit? Didn't you make that into evidence?
I introduced that because it appeared to me, and I did that as the appellant respondent at that time was inviting the witness to read that document into the record. And I wanted it in the record so that we could show that it's based on uncorroborated hearsay, and that's what we did. We put it in, and then we sought to point out the fact that it was uncorroborated hearsay. The solicitation that's complained of, that is alleged to have occurred, is a termination violation under the MOU, and that's the only charge that lists termination as a possible outcome. The personnel policy against soliciting bribes, etc., was stipulated out of the case in open court by the parties at the suggestion of the court. And it's pretty clear that the court stopped, the trial court stopped up short and did not continue on to 322H and do the searching review of the record. Had that happened, it would have been clear that while the Civil Service Commissioner based her decision on an unenforceable MOU and a policy suggesting bribery that had been stipulated out of the case, those things were not available in the record that he reviewed. So on the record as a whole is an interesting concept. At that point, the record was not whole. The record was unwhole because it didn't have those critical pillars that the Civil Service Commission had relied upon in reaching their decision to terminate. It is just simply a fact. It did not appear to reflect the search and review of the record that would have disclosed that, and it certainly didn't appear in the order, in the decision that the court entered. There is clear case law that uncorroborated hearsay cannot support a substantial and material standard for this court, or frankly for the trial court. once you take out the MOU, once you take out the bribery policy, all you have is Exhibit 1 and Exhibit 4, the two documents that Director Connect, Public Works Director Connect, said that he relied on when he decided that he was going to terminate Mr. Washington. Once you take out those two pillars, the stool that the city's case works on simply collapse.
What about the testimony of the complainant that was quoted by Mr. Hawkins?
Her testimony, quite frankly, is that he was being rather bold and boastful, but when asked pointedly, did he ask you to allow him to do the work? She said no.
You heard the quote. You heard the quote that Mr. Hawkins read to us. Do you disagree that that's a quote?
No, that's more or less in the record. I'm not contesting the record. What I'm saying is, well, I'll say this. My wife and I dated for a period of time before I asked her would she marry me, and she didn't say yes until I asked her. Well, whatever Mr. Washington was saying did not equal or arrive to the level of a request to be allowed to do the work. And that's what this case is about. That's what this case is about. And
you don't think we can conclude from that statement that he was soliciting the work, whether or not he specifically quoted a fee to do the work?
I think she was asked a direct question, and it didn't appear to me that she concluded. It aggravated her, but it didn't appear to me when she said no, he didn't ask to do the work. I think it would be more reasonable to conclude that whatever was the gist of that conversation, or whatever he was saying, did not rise to the level of a request or a solicitation. At best is ranked bluffing or rank boasting or embellishing himself. And when he was asked about that in his testimony, he said, well, yeah, I'm the only code enforcement inspector that has a contractor's license. And I think that makes me more qualified than anybody else. And I don't have a problem telling people that I'm that experienced, that I know that much about what I'm doing when I tell them that I'm citing them for the various code enforcement infractions that cited with.
Thank you, sir. You've used up your time. Thank you very much for your argument today, and we'll get you an opinion as soon as possible. Thank you.
Thank you.
Thank you all.
This honorable court is now in recess until 2 p.m.